of Rizky Karo. Bapak Rizky Karo, are you already in the room?
Yes, we are ready, sir.
Yes. Okay. So who will be presenting first? Larissa?
Larissa, Selfie, and
Okay.
okay. Allow me to share screen.
Yes, please. The time is yours. It's gonna be 10 minutes, and I will give you a reminder if it's time's up.
Good afternoon, ladies and gentlemen. Mr. Siraj Okta as our chair panelist today, Mr. Andreas Rumkorp, and all presenters who joined this conference. Allow us to introduce ourselves. My name is Nimade Indira from batch 2020, Fakultas of Law, Pelita Harapan University, with my fellow teammates Clarissa Samantha and Selina Tania from batch 2021, Faculty of Law, Pelita Harapan University. Before we start, we would like to say thank you for giving us the opportunity to present our research paper regarding the authority of the village head to be a mediator in the event of customary agreement dispute in Piliana Village Central Maluku Regency, Maluku Province. Indonesia appreciates the understanding of national unity and has great respect for diversity in society, specifically related to indigenous people. This commitment states in Article 18B, paragraph 2 the 1945 Constitution of the Republic Indonesia that the state shall recognize and respect entities of the adult law societies along with their traditional rights to the extent they still exist and are in accordance with the development of the society and the principle of the unitary state of Republic of Indonesia, which shall be regulated by law. Therefore, Indonesia acknowledge and respect customary law as one of the regulation that applies in Indonesia. This scientific work is the outcome of research conducted by the Faculty of Law, Pelita Harapan University, under the auspice of the Institute for Research and Community Service, Pelita Harapan University. Pilana Village, Tehel Country, Central Maluku Regency, and Pilana Village is one of the area at the base of Mount Binaya in Indonesia Central Maluku Regency. And according to the pastor Piliana Village, the customary law in Piliana Village is extremely strong, and the villagers favor it greatly.
When we talk about customary law, we should know that customary law is basic, straightforward, and concrete. In addition, customary covenant law has principles based on the spirit of kinship, harmony, and willingness to assist. That makes indigenous people's fulfillment of unwritten agreements depends on mutual trust. And that trust is based on their tremendous intensity of relationship and communication between indigenous peoples in their daily lives. Thus, a sense of confidence are built since they are already familiar with each other and allow them to create a verbal agreement. However, oral agreements are straightforward and lack of complex legal ties. Oral agreements have the drawback of causing substantial injury to the parties. Nevertheless, what about the resolution of defaults? The second problem is what happens if the oral agreement's default is litigated in the appropriate district court. The parties will struggle to present a defense, and the parties may neither confirm or deny the existence of such oral agreements. One agreement is one of the examples. Sorry?
Is this the slide is still on the introduction? Is that correct?
Yes, that's correct.
Okay.
Okay, let me.
Yes.
Bond agreement is one of the example of customary arrangement in Piliana Village. Generally, the bond deadline is determined by the harvest season of the plant. This oral or unwritten agreement contains the potential for controversy. And so, in case there's confrontation in Piliana Village, the village head should have the authority to settle disputes, and the leader of the community should act as the mediator.
And now we move on to the main issue of the topic. Based on the results and the research that title we raised, the formulations of the problem is how the authority of the head of village as a mediator in Piliana Village. According to normative juridical methodology, our research techniques use secondary data that is gleaned from primary, secondary, and tertiary legal source. We employ that qualitative analysis as our method of analysis. The primary source of law that we use is the 1945 Constitution of the Republic of Indonesia, Law Number 6 of 2014 concerning village, and other regulations that related to the topic. Then the primary legal materials from from the Galakha BBI and the dictates of the Black Law are then added along with secondary legal materials drawn from relevant scientific articles. The next source of primary information comes from the social legal study, which is based on direct informants. We rely on to search, which is the village head or Raja Piliana Agustinus Leopatoa, and Pastor Carlos Titanea from Piliana village. Finally, we elaborate on secondary data to generalization.
Now we move on to our results and analysis. Based on the research and analysis that we gathered, we can tell that according to the results of an interview with the head of Pilana village, the community met an oral phone agreement. There was no written contract because the community in Pilana village was still bound by the kinship system. Therefore, the agreement was executed in a familiar manner. Pilana village community engaged into a phone agreement for economic reasons, either as the lead giver or as the lead recipient. And when we talk about agreement, we have to refer to the positive law of Indonesia, in which we will find the organization of contracts in the Indonesia civil law. Article 30 and 20 of the Indonesia Civil Code regulates the condition for the validity of a contract, which are as follows. First, agree on those who commit themselves. Second, the power to make an engagement. Third, a specific thing. And fourth, a justifiable purposes that the parties are required to abide by the duties stipulated in the agreement. A verbal agreement that is acknowledged by the parties may nonetheless be contested. The oral agreement is still valid and has the legal force to declare a person in default. However, if the oral agreement is denied or doesn't recognized by the party suspected of default, the oral agreement has no longer the legal force to declare a person in default, because the agreement may be true or may not exist depending on the evidence of the parties.
Sally has explained that from a legal standpoint, verbal agreement can often be as valid as written agreement, and the villagers of Pilana village are likely to make a verbal agreement. However, if there is a dispute between the villagers, the disputes can be solved by mediation and the village chief can act as a mediator. The village head is authorized to serve as a mediator in the event of dispute between villagers. The authority of the village head to act as a mediator is expressly stated in Article 26, paragraph 1 of the village law that states, the village head is responsible for organizing village, implementing village development, and empowering village communities. In addition, in Article 26, paragraph 2, explains that the village head is authorized to lead the implementation of village government and promote peace and order within the village community in the performance of his duties. Therefore, it is the responsibility and the authority of the customary head to mediate the negotiation process and assist the disputing parties in reaching settlement. Professor Jojo Dibuno thinks that traditional chiefs serve as governments whose duty is to announce a stance of justice if either partners in relationship commits wrongdoing. Therefore, based on the findings of this research and interviews with the village head of Piliana, the village head can assist in the resolution of resident issues. And due to the fact that the village chief in Piliana is also the traditional chief, his existence is widely referred and the parties to the conflict can view his decision as just.
If the mediation process leads to a settlement, then parties might create a peace agreement that must be signed by the mediator and the parties. In accordance with Article 36 of Supreme Court Regulations, number 1 of 2016 concerning mediation procedure in courts, this document can be reinforced into a settlement agreement by filing a case with an appropriate court. Article 36, paragraph 1 states, parties with or without the assistance of a qualified mediator who successfully resolve a dispute outside of court with a peace agreement may file a peace agreement with a court empowered to obtain a deed of peace. Nonetheless, if mediation fails, residents have the options of filing a lawsuit with the court in the Masohi District Court, Masohi City, Central Maluku. By the end of the presentation, the research appreciates the support from Head of Institute for Research and Community Service, Pelita Harapan University, Head of Piliana Village, and Press in Piliana Village. We are very sorry for all the imperfections and we would like to say thank you for all the support and attention for this presentation. Do you have any questions, sir and ma'am?
Okay, thank you so much for the presentation regarding the Piliana village mediation and the role of the village head. And then I think I need to we need to change the format of this session, this panel, because we still have 4 more speakers. So we will keep the question and answer session in the back before we close the session. So we will proceed with the third presentation.